document that proved Bondi lied under oath. The Epstein client list she swore didn't exist. There is a list, not an allegation, not a theory, not a document that someone claims exists but that no one has been able to independently verify. A list compiled by federal investigators, cross-referenced against flight logs, financial records, and witness testimony gathered over years of one of the most expansive federal investigations in American legal history. A list of names, specific, documented, sourced, of individuals who used Jeffrey Epstein's trafficking operation, men of wealth and influence whose connection to what Epstein ran was not speculation but recorded fact, preserved in the investigative files of the United States Department of Justice. That list exists. It has always existed. The law required it to be released, and the person legally required to release it sat in a congressional hearing room under oath and swore it already had been, while Joe Neguse held the proof that it hadn't. The room went silent for reasons that had nothing to do with surprise. What happened next detonated the room, not metaphorically, not in the political sense of a story that generates controversy and disappears into the news cycle. In the specific, irreversible sense of something being said on the record that cannot be unsaid, evidence being presented that cannot be unfiled, a question being asked in public, under oath, with cameras running and a stenographer recording every word, that the Attorney General of the United States had no answer for, and knew it before she walked through the door. She had walked in with a binder. That detail matters more than it sounds. Not a legal brief, not a prepared defense of her department's document handling decisions. A binder, assembled by staff, filled with attack lines, personal jabs at Democratic committee members, pivot material designed to change the subject when the subject became too uncomfortable to address. That is the preparation the Department of Justice made for a congressional oversight hearing into the handling of the most consequential investigative files in modern American history. You do not bring a binder full of attack lines to a hearing when you have answers. You bring it when the answers are the one thing you cannot say, when the legal position is indefensible and the documentary record is damning. And the only remaining strategy is to make the hearing painful enough for the people asking questions that they eventually stop. The binder was a confession before the hearing began. The document Joe Neguse brought was the proof. This is the story of how that moment happened. What was in the room before it? What was in the document when Joe Neguse held it up? And what it means that the woman responsible for delivering justice to over 1,000 survivors of Epstein's trafficking network sat 3 feet from that document and tried to pretend it didn't say what it said. The hearing had been building toward this for weeks before it convened. The legal deadline for the release of the complete unredacted Epstein files had passed. The Department of Justice had released what it chose to call a complete disclosure, a curated, managed version of the investigative record that congressional reviewers quickly identified as something other than what the law required. Names were missing. Entire categories of documentation were absent. And the specific category that was most conspicuously, most deliberately, most consequentially missing was the one that the survivors had been fighting for years to make public. The client list. The names of the men who had used the network. Not the name of the man who ran it. Epstein was dead and his conviction was a matter of public record. Not the name of his co-conspirator. Ghislaine Maxwell had been tried and sentenced, and her role in the operation was documented in court filings available to anyone who wanted to read them. The names that were missing, the names that the DOJ's curated release had declined to produce, were the names of the individuals at the other end of the transaction. The men who had flown on the planes, attended the events, participated in what the federal investigation had documented as a systematic, organized, multi-decade operation of sexual trafficking and abuse. Those names were in the investigative record. They had always been in the investigative record. Federal investigators had spent years building the evidentiary case that connected those names to that operation and the product of that work. The client list, the documented identification of Epstein's network of participants, sat in government files while the Department of Justice told Congress the release was complete. The congressman had reviewed the files personally. He had traveled to the Department of Justice, sat in a secure room, and gone through the materials that had been produced. He had compared what was there against what the law required to be there, and what he found. The specific, documented gap between the legal mandate and the actual production was the thing he carried into that hearing room. That trip to the DOJ is worth pausing on, because it represents something that should not have been necessary. A sitting member of Congress traveling to a government building, requesting access to investigative files, sitting in a controlled environment to review them and finding, in the department's own records, Evidence that the release his own committee had been told was complete was not complete. That sequence of events is the institutional failure made physical. The congressman had to go find the evidence of noncompliance in the files of the noncompliant department because the department had declined to produce it voluntarily. He did the work the subpoena should not have required him to do. And what he found when he did it was a document number attached to a list that had been left out of a release that a senior DOJ official had just described under oath as complete. He did not announce what he had when he walked in. He did not lead with the conclusion. He built toward it methodically, the way someone builds toward a revelation when they understand that the revelation will only land with its full weight if the room understands exactly how far the gap is between what was promised and what was delivered. He started with the law. The statute was clear. The mandate was explicit. The permissible redactions were defined with specificity. Information that could identify victims and survivors was to be protected. Everything else was to be released, not summarized, not characterized, released. The actual documents, the actual records, the names the investigation had documented. Then he described what had been produced instead. He walked the room through the categories of documentation that were present in the legal mandate and absent from the actual release. The financial records that had been summarized rather than produced in full. The witness testimony that had been characterized rather than disclosed. And then the specific category, the one that sat at the center of everything the survivors had been fighting for. The identification records, the documents that connected specific named individuals to specific documented participation in Epstein's operation. The client list, he said, had not been produced. Bondi said the release was complete. He held up the document. It was a page from the investigative file, a single page pulled from the materials he had reviewed in the secure room at the DOJ. It contained something specific, not a summary, not a characterization, a reference. Explicit, sourced, cross-referenced against other materials in the file to a compiled identification record, a list with a document number, with a filing date, with a physical location in the DOJ's own record system, one page, one document number. And it ended the hearing's pretense entirely. The document he was holding proved the list existed. It proved the list had a document number. It proved the list was in the DOJ's possession. And it proved the list had not been included in the release that Bondi had just described under oath as complete. The room did not make a sound. There is a specific quality to the silence that falls in a congressional hearing room when a physical document contradicts a sworn statement in real time. It is not the silence of confusion. It is not the silence of people trying to process something unexpected. It is the silence of people who have just watched the foundation of an official position collapse under the weight of a single piece of paper. The reporters in the gallery recognized it. The committee members recognized it. The aides along the walls recognized it. It is the silence of recognition, of people understanding simultaneously that what they are watching is not a procedural dispute or a political argument or a difference of legal interpretation. It is the silence that falls when a line meets the document that disproves it. And both of them are in the same room at the same time with nowhere to go. This kind of silence has a temperature. It is cold, not aggressive, not hostile, cold. The cold of a room that has just processed something it cannot unprocess. The cold of understanding settling into people who came expecting performance and found something else instead. A document number, a filing date, a list that the law required to be released and that the Attorney General had just sworn under oath had been released, while the congressman held the proof that it had not. Bondi recognized it. And what she did in the 3 seconds after that silence fell is the thing that defines everything about her tenure as Attorney General. She did not say, "I was not aware that document had not been included, and I will ensure it is produced immediately." She did not say, "The document you are referencing is subject to a specific legal protection that I can explain on the record." She did not say anything that engaged with the document in his hands as the thing it was, a piece of the federal investigative record that had been withheld in violation of the explicit legal mandate she was sworn to execute. She said the release was complete. He read from the document again, slowly, the document number, the filing date, the explicit cross-reference to the compiled identification record, the client list, that the document proved existed, and that the DOJ release had not included. She said the release was complete. He looked at her for a moment, the kind of look that happens when someone has prepared for a hearing expecting to be surprised, and has found that the reality is worse than the preparation. When the gap between what you anticipated and what you are witnessing is large enough that you need a second to absorb it before you can speak. That pause lasted 3 seconds. In a congressional hearing room, 3 seconds of silence is a geological age. It is long enough for every person in the room to understand that what they are watching is not a hearing anymore. It is a reckoning. The kind that happens when the gap between the official story and the documented reality collapses into a single physical object, a page from a federal file, and the person who built the official story is sitting 5 feet away from it with nowhere to go. The reporters in the gallery were already writing. Then he said, "You just told this committee under oath that the release was complete. I am holding a document from your own department's files that proves a compiled identification record. A client list was not included in that release. Those two things cannot both be true. One of them is a lie, and the one that is a lie was just told in this hearing room under oath by you." The silence that followed was longer than the first one. This was not a procedural dispute. This was not a difference of interpretation about what the legal mandate required or what the permissible redactions covered. This was a document number, a filing date, a physical location in a record system, facts that do not have alternative interpretations, facts that either match the release inventory or do not. And the document in the congressman's hands proved they did not. Watch what happens when a witness runs out of road. This was it. Bondi's legal team seated to her right was visibly processing the moment. The kind of processing that happens when you are a lawyer in a hearing room and your client has just been caught in a direct contradiction between sworn testimony and documentary evidence, and you are calculating the exposure in real time and finding that the calculation does not produce a comfortable number. Bondi said, "The Department of Justice has complied with all applicable legal requirements." He said, "The document I am holding is from the Department of Justice's own record system. It has a document number. It references a compiled identification record that was not in your release. Where is it?" She said, "Our review determined the release was complete." He said, "Your review missed a document that is in your own files, or your review found it and decided not to include it. Which one is true?" She opened the binder. That detail, the binder appearing in that specific moment, is the detail that tells you everything about the preparation that had gone into that hearing. The binder was not full of legal justifications for the redaction decisions. It was not full of documentary evidence supporting the completeness of the release. It was full of attack lines, prepared deflections, personal jabs at committee members designed to change the subject when the subject became too dangerous to address directly. The subject had just become too dangerous to address directly. Think about what that choice reveals. In the moment when a congressman holds up a document from your own department's files that directly contradicts your sworn testimony, two options exist. You address the document, or you reach for the binder. Addressing the document requires either explaining the discrepancy, providing the legal justification for why the identified record was not included in the release, or acknowledging the error and committing to correcting it. Both of those options require engaging with the reality of what the document shows. Reaching for the binder requires only the willingness to pretend that the document in his hands is less important than the attack line on the page in front of you. It requires the belief that the room's attention can be redirected through performance when it cannot be answered through fact. It requires, in the plainest possible terms, the decision to treat a congressional oversight hearing as a problem to be managed rather than an obligation to be met. She managed. She did not meet it. She read from the binder. Something about the previous administration, something about the timeline of the original investigation, something designed to move the room's attention from the document in his hands to a political argument about who was responsible for the failures that predated her tenure. He did not let the room move. He said, "I am not asking about the previous administration. I am asking about a document that is currently in your department's files that was not included in a release your department described as complete, and that you have now described as complete twice in this hearing room while I am holding proof that it is not. Where is the client list?" The room was very still, because that question, where is the client list, is the question that the entire architecture of the DOJ's Epstein file management had been constructed to prevent from being asked in exactly this way, with a document number, with a filing date, with physical evidence of the list's existence in the department's own records, with a sworn statement of completeness that the document directly contradicted, in a hearing room, on camera, in front of Congress. The survivors of Epstein's operation had been asking that question for years. In courtrooms, in legal filings, in congressional testimony, in public statements, in the kind of personal advocacy that cost people more than most people ever know. They had been told the release was ongoing. They had been told the process was complex. They had been told that the legal requirements for protection of sensitive information made full disclosure difficult. They had been told in 100 different ways to be patient. The patience had a texture that only people who have waded through deliberate obstruction understand. One investigation that ended without accountability. One plea agreement that shielded the men around Epstein. One death in a federal jail cell that closed the prosecution before the reckoning arrived. Each delay was not complexity. It was a choice made by people with the institutional protection to make it without consequence. Joe Neguse was removing that protection. He held the document and waited. Bondi said the department had complied with all applicable legal requirements. The question landed in the room the way very few questions land in congressional hearings. Not with procedural force. Not with parliamentary authority, with the weight of everything it implied. Where is the client list is not a technical question about document management or redaction standards or release inventory compliance. It is the question that the survivors of Epstein's trafficking network have been asking for years in every forum available to them. It is the question that the federal investigation spent years generating the answer to. It is the question that the DOJ's entire Epstein file management strategy had been constructed, elaborately, expensively, with the full institutional resources of the nation's top law enforcement agency, to prevent from being answered in public. And it had just been asked in public, with a document number, with a filing date, with physical evidence of the list's existence sitting on the hearing table, under oath, on camera, in front of Congress. The binder had nothing for this. He said, I will be submitting this document to the committee record. I will be requesting a formal accounting of all identification records in the DOJ's Epstein investigation files that were not included in the release. And I will be requesting that accounting in writing within 5 business days under the authority of this committee's oversight jurisdiction. Then he looked at her one more time, and he said, the survivors in this country have been waiting for those names for years. You just told them, under oath, that the release was complete. This document says it wasn't. Someone is going to have to explain that. And based on what I've seen in this hearing room today, I don't think it's going to be you. The room let that land. The binder stayed closed. What happens now is not complicated in its structure, even if it is complicated in its execution. The document has been submitted to the committee record. The formal accounting request has been made. The deadline is in the congressional record, and the sworn statement that the release was complete is sitting in the permanent transcript next to the document that proved it wasn't. Those two things, the sworn statement and the contradicting document, are now the gravitational center of everything that follows. Every subsequent hearing on the Epstein files will reference them. Every subpoena issued for additional documentation will be grounded in them. Every legal proceeding that touches on the completeness of the DOJ's release will begin with them. Consider what the 5-day deadline actually means. It means a sitting member of Congress, in a formal oversight hearing on the record, has given the Department of Justice a specific bounded window to produce documentation that was legally required to be produced months ago. When that window closes, one of two things happens. The documentation is produced, in which case the question of why it wasn't produced before becomes the center of the next hearing. Or the documentation is not produced, in which case the failure to comply with a formal congressional accounting request issued under oversight jurisdiction becomes the basis for the next subpoena. There is no third option. There is no version of events in which the deadline passes and the hearing room moves on to something else. The document number is in the record. The deadline is in the record. The sworn statement that the release was complete is in the record. And every one of those things is pulling in the same direction, toward the list. The names on that list, the names that the federal investigation documented, that the legal mandate required to be released, that the curated DOJ disclosure chose to bury, are still in a government file somewhere, attached to a document number that a congressman read out loud in a federal hearing room while the Attorney General of the United States opened a binder and looked for something to say. She didn't find it. The list is still there. The document number is now public. The 5-day clock is running. And the survivors who have been waiting for those names, the ones who traveled to that hearing room and sat behind the witness table and watched the Attorney General reach for the binder instead of the truth, are still waiting. The clock has never been closer to zero. And when it reaches it, the list will either be in Congress's hands, or the reason it isn't will be in the permanent record instead. Either way, the thing that Pam Bondi built her entire Epstein strategy around preventing, the moment when the room runs out of patience and the document number becomes a subpoena, is no longer a future possibility. It is the next thing that happens. The list has a document number. The document number is now in the congressional record. The sworn statement that the release was complete is also in the congressional record. And somewhere in a government building, in a filing system that has a specific location code attached to that document number, the list itself is waiting. It has always been waiting. The only thing that changed in that hearing room is that now everyone knows exactly where to look. And the woman who was supposed to make sure no one found out is on the record saying it doesn't exist, while the document that proves it does sits in the congressional archive. Permanent, time-stamped, real. There is a version of power that functions only in the dark. That depends on the gap between what is documented and what is disclosed. That survives only as long as the people with the authority to demand the full record choose not to use it. That version of power had been operating in the space between the Epstein investigative files and the American public for years, sustained by incomplete releases, managed disclosures, curated productions that omitted exactly the category of information that would have made the names in those files undeniable. That version of power walked into the hearing room with a binder. It walked out with a document number in the congressional record and a production deadline that now has teeth. The light is on now, and the list is still in the file, exactly where the document number says it is, exactly where the law said it should have been released, exactly where the congressman said he would look. He is still looking. The hearing ended. The cameras packed up. The legal teams gathered their materials. Bondi's staff collected the binder that had attack lines for every question except the one that mattered. The one about a document number attached to a list that the law said should have been in the public record months ago. The room emptied. The document number stayed in the record. The sworn statement stayed in the record. The clock kept running. And somewhere in the Department of Justice tonight, someone is looking at that document number and understanding what the coming days mean. Not for the hearing, not for the political narrative, not for the attack lines in the binder. For the list, for the names. For the men whose connection to Epstein's operation was documented by federal investigators and recorded in a file that a congressman just proved exists and a sworn statement just proved was hidden. The detonation happened in the hearing room. The fallout is still spreading.